Hello, my name is Jen Sheldon, Investigative Counsel. I'll be presenting on outside practice, outside employment, and client diversion issues we've seen in the past. All three of these issues are related to each other, so each section will overlap with the others. The outside practice of law, unless under one of the allowable exceptions, such as representing family members, a charity, or if court-appointed and uncompensated, is a violation of 45 CFR 1604, but can also be criminal if the attorney is working the outside cases during program work hours. This regulatory violation would then become time and attendance fraud. One case we had involved a program's managing attorney and staff attorney. Neither sought permission to engage in the outside practice of law, but they accepted compensated civil cases from non-program clients. They accepted court-appointed guardian ad litem cases, which Part 1604 does not allow. The managing attorney accepted court-appointed divorce cases, included the program's name and address on pleadings for non-program clients, and used program support staff to draft pleadings for private cases. They both assisted private clients during program hours. So how was this outside practice uncovered? Well, the grantee received numerous complaints from clients, and then when they delved deeper into this issue and looked at the attorney's case files, they found that each attorney had over 200 cases that were open. The outcome was that the program received a question cost from LSE for over $20,000 based on time and attendance records. So what are the best practices to prevent a case such as this at your program? Well, the first step is to create a system for receptionists to report large numbers of complaints on a specific attorney. Periodically check court records for attorneys to ensure that they are working program cases, and regularly remind employees they should not be working to assist attorneys with any outside practice. The best way to prevent the outside practice of law is to create a robust outside practice of law policy that initially educates and instructs newly hired attorneys on the restrictions of Part 1604. And this includes mechanisms for periodic reminders to all employees concerning the restrictions, and that the outside practice of law must receive prior written approval by the executive director or whomever he or she designates to approve the requests. In addition to a comprehensive policy, we suggest that programs create an outside practice of law form that is renewed at least annually. The form should include a description of the outside work, the name of the person being assisted, the case number, an estimate of how long the outside practice of law will occur, and an estimate of the total number of hours needed to complete the work. And additionally, a certification that the attorney will inform the appropriate administrator when the outside practice of law has concluded. If the outside practice of law request is by the executive director, then that determination and approval should be made by the program's board of directors. Moving on to outside employment, although it produces many of the same risks that outside practice of law presents, LSE does not have a regulation requiring an outside employment policy, but we strongly encourage grantees to create one. We've had outside employment by employees that have led to cases of employees diverting income-eligible clients to their own outside business for a fee. Employees working that outside employment during grantee hours, amounting to time and attendance fraud, and using the guise of grantee travel to conduct their outside employment, which would amount to travel fraud. We suggest at a minimum that, similarly to the outside practice of law, grantees adopt policies which require the written disclosure and written approval for all outside employment, and create an outside employment form requiring staff to certify that the outside employment will not conflict with program work hours or mission. And for more suggestions and indicators of outside employment, please go to the OIG website and review Fraud Alert 17-02 on outside employment. Next, we're going to talk about averted aid, which will delve deeper into numerous cases we've seen where attorneys and paralegals have used their outside practice or outside employment to divert both over-income clients and income-eligible clients to their outside business for personal gain. We've had multiple cases where paralegals or attorneys have used their positions at the grantee to divert both ineligible and eligible clients to their outside paralegal business or outside practice for personal benefit. We've also had cases where a grantee employee has directed a client to their outside translation or process serving business for personal benefit, and the employee has never disclosed their outside employment to the grantee. In some instances, the clients were eligible for free legal services, but were wrongly informed by the employee that the grantee could not handle their case. In other instances, the clients were not eligible for free legal assistance and were diverted by the employee to an associate, accomplice, or themselves in violation of grantee policies. In most cases, the grantee employees took advantage of a lax intake system, and the client was diverted before they were entered into the case management system. Subjects referred for prosecution involving the diversion of clients include grantee paralegals, attorneys, intake staff, and contract attorneys. In each case, the prospective client was diverted during the intake process, including intakes occurring in person, via telephone, and during outreach events. Additional cases also found grantee employees that diverted clients for payment of services such as translation, notary public, and process serving. In these instances, the employees did not notify the grantees of the outside work and potential conflicts of interest. Grantees must adopt sufficient policies to ensure sensitive client information is recorded and secured in the case management system. Otherwise, clients and prospective clients become vulnerable to diversion and fraud. In order to protect against the diversion of clients at your program, grantee policies covering the oversight of the client intake process and the administration of the grantee case management system must adequately protect clients. Also, grantee policies related to the outside practice of law and to outside employment should prohibit the employee from engaging in outside work that may constitute a conflict of interest with the grantee mission of providing legal services to low-income clients. This slide outlines just some of the best practices that are aimed at preventing outside practice, employment, and client diversion. One of the better things to do is to create a strong outside practice and employment policies and forms, and implement a conflict of interest policy. Require prior approval of all outside practice and employment, and periodic internet searches on employees to detect outside work. Check time records against court dockets and travel records, and ensure intake procedures create an audit trail of clients. And please do not share passwords.